Oh, once again, the image of the United States Ninth Circuit Court of Appeals as a leftist stronghold are being shattered. On Friday, August 14th, a three-judge panel of the federal court ruled against the state of California's retroactively applied so-called large capacity magazine ban of ammunition mags that can hold more than 10 rounds, dealing a really harsh blow to Governor Gavin Newsom's leftist gang. Hi everyone, I'm Gardner Goldsmith for MRC-TV. Large capacity magazines. They're not 20-year-old double issues of Reader's Digest that somebody finds at a yard sale.
What's inside this capsule may help prevent the flu, colds, and even ease arthritis. It's vitamin E, and you learn about it in Reader's Digest.
No, not at all. They are what politicians say they are, and of course they're terribly evil, according to the politicians. Or perhaps it's the politicians banning them that's evil. Well, to get into this, we can rely on the great Brian Doherty of Reason Magazine, who expertly explains the situation coming out of the Ninth Circuit. Quote, "The decision in the case of Duncan v. Becerra upheld a district court decision for summary judgment against the state of California from March 2019. The law barring LCMs, as currently amended, was a result of Proposition 63 in 2016. Okay, so enforcement of the amendment to the California statutes, the amendment entitled Section 32310, was stopped by a suit brought by California residents Virginia Duncan, Richard Lewis, Patrick Lovett, David Marguglio, Christopher Waddell, and the California Rifle and Pistol Association. And a 2-to-1 majority of the Ninth Circuit panel just upheld this previous district court ruling on the suit, a ruling that prevented the amended statute from actually being enforced. So, in short, Friday's Ninth Circuit action means that unless Javier Becerra, the Attorney General of California, takes a new appeal all the way to the U.S. Supreme Court, anyone prosecuted by Governor Newsom under this amended statute will be allowed to go free. It essentially prevents the executive branch of California from enforcing the statute because anyone prosecuted under it will go through a court system that's already found that the large capacity magazine ban is unconstitutional. Now, Doherty also notes that the three-judge panel majority not only looked at the California government's infringement of the Second Amendment, but at its infringement of the Fifth Amendment, which already has been cited by the lower court. The district court had held that there was, quote, no genuine dispute of material fact that Section 32310 violates the Second and Fifth Amendments of the United States Constitution and ordered summary judgment for the LCM owners, end quote, who were suing the state. The Ninth Circuit Court of Appeals today agrees with that conclusion. And the majority on the panel found that the infringement of the Second Amendment is very clear. Judge Kenneth K. Lee wrote today's Ninth Circuit panel decision, in which he was joined by Judge Consuelo Callahan. The judges concluded that barring citizens from owning and using more than half of the magazines for sale in the United States, ones that come along with a wide variety of commonly purchased handguns, strikes to the core of the Second Amendment right to own arms for self-defense, since the LCM ban barred possession of a self-defense tool commonly used for lawful purposes. But some leftists might overlook how the California government was ready to infringe on the Fifth Amendment. This is understood by clearly recognizing the fact that the Fifth Amendment, in part, prohibits any government from depriving people of life, liberty, or property unless those people have been afforded what's called due process of law. Now, this is, of course, defined by the government, but it's based on an old British common law tradition. The Fifth Amendment also prohibits the taking of property without what's called just compensation. Again, sadly, defined by the government, but it is within the Fifth Amendment. So, since this California amendment is supposed to claim for the California government the power to criminalize possession of so-called large capacity magazines, it could have been used to deprive people of their property without due process and without just compensation. And of course, prohibition of future sales is already something that stands contrary to the Second Amendment. So that's what was ruled by 2 judges of the 3 on the panel. But that leaves the question open. How hard is it for the 3rd judge to have grasped these very basic concepts? And how about California Governor Gavin Newsom or California Attorney General Becerra? And how about other nuances woven into the history of gun prohibition? First, there's the fact that prohibition not only doesn't prevent criminally minded people from obtaining the prohibited firearms and magazines, thus putting the law-abiding and cops in greater danger, but there's also the fact that prohibition has been used as a lever for racial injustice. Brian Doherty observes that Judge Lee actually discussed this. Perhaps the most poignant and persuasive reminder of the fundamental right to self-defense, the denial of that right to Black Americans during tragic chapters of our country's history. Post-Civil War state legislation and the Black Codes in the South deprived newly freed slaves of their Second Amendment rights. Meanwhile, armed bands of ex-Confederates roamed the countryside, forcibly disarming and terrorizing African Americans. Our country's history has shown that communities of color have a particularly compelling interest in exercising their Second Amendment rights. The Second Amendment provides one last line of defense for people of color when the state cannot or will not step in to protect them. The right to self-defense against predators. Absolutely essential to remember. And in fact, it's essential to remember that the state is a predator. The largest, most powerful, longest standing predator in human history. You know, the majority on the Ninth Circuit panel ruled correctly. But the very fact that they had to rule on this offensive California amendment ought to be a wake-up call to anyone who lives in the fever dream that government is his or her friend. Too many millions of people have perished because of that fraudulent assumption about government. And the only thing that can stop the state are awareness of fundamental human rights, weapons, and people willing to use them for self-defense. Thanks so much for watching, everybody. Remember to like and subscribe. I really appreciate being able to read your comments in the comments section on YouTube, so feel free to fire away with any of your opinions. And please remember to go to MRCTV.org. That's MRCTV.org. I'll mention that again, MRCTV.org, to find out what the whole team is doing. And if you want some great MRC items, go to MRC-Store. We'll see you on Facebook and the MRC-TV Facebook page. We'll see you on Instagram. And I'll see you in the comments section on YouTube. For MRC-TV, I'm Gardner Goldsmith.